I have extremely big breaking news. We have a decision by a federal judge in New York striking down the vast majority of New York's new gun control laws. He let a lot of stuff stand, some of which I think is a mistake, but the bottom line is a huge amount of New York's new crazy gun control laws that they rushed out and passed in the wake of NYSERDA versus Bruin has been struck down as unconstitutional under the Second Amendment. I'll explain the details in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, best-selling author, member of the United States Supreme Court Bar, and proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay, major news, folks. I have in front of me the approximately 65-page decision in the case of Antonuk versus Hochul against Kathy Hochul. This is a decision by Judge Glenn Suddaby of the Northern District of New York. If you recall, this is the judge that basically said the vast majority of New York's new gun control laws governing carriage, meaning carrying handguns in public for self-defense in the wake of NYSERDA versus Bruin. He wrote several weeks ago, he thought a lot of this was unconstitutional, but he thought that the plaintiffs lacked standing, so he was not going to effectively effectuate his decision and strike down the laws and enjoin them from being enforced just yet. But he just did that today because there's new plaintiffs here that he concluded clearly have standing to sue. And based upon that, he went forth and set forth in extreme detail why he thinks much of New York's new gun control laws governing the carrying of guns in public for self-defense is unconstitutional. I'm going to go fast with this. We can do a deeper dive later, but let me hit the highlights. Much of which, by the way, you would have anticipated if you've been following this channel as to where they screwed up New York State. And it's going to get crazier and crazier, but let's cut to the chase. The first thing is, he said that the requirement of good moral character and the application of open-ended discretion was unconstitutional. What I mean by this is he pointed out that what New York had done is before NYSERDA versus Bruin, New York had said that they got to exercise discretion whether or not whether you needed to carry a gun. But what happened after NYSERDA versus Bruin, where the Supreme Court said that you can't exercise discretion as to whether or not a person needs to carry a gun, New York changed the law and basically says we're going to start exercising our open-ended discretion, not to determine whether or not you need a gun, whether I need a gun for self-defense, but to determine whether or not you have good moral character and I have good moral character. The judge here said no way, no how. The presumption is we are entitled to carry a gun in public for self-defense, and the burden of proof is actually going to be on the government to establish that we are not entitled to carry a gun because we represent a danger to others. We don't have to prove that we have good moral character. It's up to the government to show that we don't have good moral character. And he cut back dramatically on the ability of the government to do so on the grounds that basically the government, New York was trying to do an end run and say that they had the discretion to determine who was good and bad to carry a gun. And the judge says, no way, no how, that's not how it works. So he made it very clear that any standards have to be objective. And we've talked about this in other videos. The Supreme Court says that standards as to whether or not you can carry a gun have to be objective, they have to be narrow, and they have to be definite. A lot of the stuff involving recommendations from family members or social media is not that. And that is why the judge actually struck down many of these. Specifically, what the judge said that he does say that there's historical analogs, and I think this is probably a mistake, but it's not a huge deal. He says that he's going to require, or he will continue to uphold, that New York can require 4 character references before you can carry a gun. He says that's fine, just to get 4 basic character references. There's some evidence that that's historically true. I don't think that's accurate, but again, for the purposes now, as of now, he says that they can continue to require 4 references. But again, I think eventually that will go away too. But that's not the end of this. Then what the judge said is it is unconstitutional to force people who want to be able to carry a gun to turn over the names and contact information of the applicant's current spouse, domestic partner, any other adults residing in the home, any adult children, whether or not they're minors, etc., etc. And basically said that that this is not allowed. He is enjoined in this component of the law where you have to disclose information about your family to the licensing officials. He also enjoined, as I predicted on various grounds, the requirement that you have to turn over any social media accounts. So if you need to list all your social media accounts, he says you don't have to do that anymore. That part of the law is enjoined in New York, is unconstitutional. That clearly should be the case, because what can a police officer do with social media accounts other than to exercise discretion to assess whether or not you have good moral character? But now that the judge says that's discretionary and not allowed, it has to be objective. It has to be definite. It has to be a narrow criteria. And checking out people's Twitter feeds is obviously very subjective as to whether or not you think they're good or bad or ugly or say stupid things or whatever. Not allowed. This judge stopped that, says it's no can, no do. He also enjoined and said it's unconstitutional to require in-person meetings. In other words, you don't have to show up and meet with the licensing officials anymore because that's unconstitutional. There's no historical analog for that in American history. And of course, again, it goes back to that's really just discretionary. This is supposed to be an objective standard. Yes, no. It's like a NICS background check that's very objective. It's yay or nay. There's no subjectivity done by the FFL, if you will. Not a perfect analogy, but you get the point. And the judge says, yes, it has to be basically objective, narrow, and definite. And forcing people to meet with law enforcement is not that. So that also has been enjoined as unconstitutional under the Second Amendment. So bottom line is, when it comes to the carriage requirements, he's narrowed it dramatically and knocked out a lot of the onerous requirements that New York was trying to require people to do. The most important one, though, is New York's attempt to basically exercise discretion when it came to whether or not you needed guns. And then they wanted to shift over and say, we want to exercise governmental discretion whether or not you're good enough to have a gun, meaning you have good moral character. We have to determine if you're good enough to carry. The court basically said no can, no how, not allowed. The burden is on the government, and they cannot do a fishing expedition to try to dig up dirt on you and prevent you from carrying a gun. That is not allowed, and he shut down tremendous number of those requirements. I will also put a link to the order down below, and you can read it. It's like 65 pages long, but you can check it out in the description to this video. Now, sensitive places. Now, the judge, I think, made some mistakes. He did a pretty good job on sensitive places. Now, sensitive places is a euphemism for gun-free zones imposed by the government. Now, what New York did is they said, if we have to give everyone a carry permit, that's fine, but we're going to basically make the entire state of New York a sensitive place or a gun-free zone and shut it down as much as we possibly can. The court did not do this perfectly. I think the judge made some mistakes and allowed certain things to stand because he looked at wrong historical precedents. We will get that cleaned up down the road, but for now, the judge did strike out a tremendous number of areas that are quote-unquote sensitive places as unconstitutional. So it's a very good start, but I don't think it's where it ultimately will be. But right now, the judge did knock out quite a few areas. That's very good news. Although not perfect news, we will make it better, in my opinion. It will get cleaned up, but right now, a great start. So what did he do? So the judge in this case said that obviously the Supreme Court's already said if it's a federal, state, or local governmental office, you can ban guns there. That's black letter law. The Supreme Court has said that. And also with polling places, you can ban guns in polling places. He also let stand, and I suspect this will get struck down the road, but he did let stand public areas. You can ban guns in public areas restricted from general public access for a limited time by governmental entity. I'm not quite sure what he's talking about there. I guess if the government ran some sort of a speech to the president and they limited guns from that event, I suspect that's what he's talking about here. But it's a little vague and fuzzy, and I don't think, again, it's unclear if that's going to be standing up over time. But for now, he upheld that and said you can ban guns there. Now, here is where I think he did make a terrible mistake. He basically says that you are allowed to ban guns in places of worship. I do not think that can possibly stand going down the road. He made some exceptions for people that have a duty to protect places of worship. But overall, he says they can ban guns in places of worship in the state of New York. Again, I think that historically that's going to get struck down the road. But right now, he did. Basically, he said that you can ban guns in places of worship unless the person is performing duties in their official capacities to protect the congregation. Then he also lets stand schools, colleges, and universities. I think that's also going to be subject to further debate because he talks about nursery schools, preschools. I don't think that's what the historical precedent shows. We've talked about this before, that the historical precedent shows that you can ban children or students from having guns on campus, but you cannot ban adults. That's the University of Virginia example at the time of our founding, where they prevented students from having guns on campus, but not the adults, not the maintenance workers, not the professors. So I think that the judge here was a little sloppy and did not nail the historical precedent right when it comes to banning guns in schools, universities, and colleges. So he allowed that prohibition to stand, but I suspect that that will not eventually stand because I think the judge did get that wrong, but I think that will get cleaned up. On the huge news front, he basically says that you cannot ban guns on subways or public transportation. So he specifically enjoined that. So it looks like you're now, if you have a concealed carry license, you're going to be able to carry a gun on a New York City subway or on a bus line or on transportation. He specifically says that the founding fathers were very clear that you're allowed to have guns in the context of transporting yourself or moving from place to place, because that was very dangerous. So he enjoined the enforcement of banning guns on places like subways. He also said that you can ban guns in public assemblies, which seem to be like player areas where they can express their constitutional rights to protest or to assemble. I think that is clearly unconstitutional, and he got this clearly wrong. I don't know, again, I was not involved with this litigation, but certainly if anyone brought to us attention the public assembly and public protest right before the Boston Massacre at the time of our founding, where John Adams points out that not only were the individuals who protested the British troops in front of the Custom House, not only were they allowed to protest, but they were also armed, and they were allowed to have those arms in downtown Boston while they engaged in the protest of the Custom House that eventually gave rise to the British shooting them. It gave rise to the Boston Massacre. In the Boston Massacre trial, where John Adams, representing the British officers, said that they were allowed to have guns while they were protesting the British. That was perfectly allowed in Boston and in American society. I don't think this judge recognized that example. I don't know if it was brought to his attention. It should have been, but I think it's probably a mistake to say you can't have guns at public protests based on, for example, the historical analogy of the protests associated with the Boston Massacre. He did say, though, that you cannot ban, the government cannot ban guns in entertainment or amusement or places where alcohol beverages are served. He basically says that that is not allowed, and it looks as if he has struck down the law saying that you can't bring guns into bars and places where there's entertainment. So it looks like he struck that down based upon what I'm reading. He also struck down the ban on guns in Times Square. He said there is no historical precedent for saying that you cannot have guns in places like Times Square. In fact, he thought the Supreme Court specifically rejected that notion. So you can now have guns in Times Square if you have your concealed carry permit, because the judge just enjoined the ban on guns in Times Square in New York City. He also, and this is quite interesting, he struck down a lot of other aspects of the sensitive places rule, dealing with child care programs, offices of mental health, homeless shelters, and the like. He points out that there's no historical precedent for banning guns in these areas, and therefore it should be enjoined and not enforced. So again, another huge win for sensitive places. And last but not least, this is a very big deal. What New York did, remember, is they defined sensitive places where you're just outright banned from having guns, such as governmental buildings. But then they also had something called restricted places. Restricted places. Now, what these restricted places were is basically your home and my home in the state of New York, meaning they said, and also place of business, I should say. So what they said is, unless, this is what New York State passed the law, unless a business owner, unless a resident, unless a homeowner posts a sign that says guns are allowed, you could not bring a gun into these places of business or these other places. And basically the judge struck that down as unconstitutional. He says that that is flipping the constitutional right on its head. The presumption is you're allowed to bring a gun into a business. The presumption is you're allowed to bring a gun into a person's home. And if someone wants to keep you out, then that is their business to do so. But it's not the government's business to make the decision for all the homeowners in New York State or for all the places of business in New York State and say no one's allowed to bring a gun into any of these places unless they put a sign up that says you're allowed to. The judge has enjoined the restricted places rule in New York. Another major win for the Second Amendment. Okay, so we're going to dig into this a lot more later, but the bottom line is this is a very major victory for the Second Amendment. It took all those silly gun control laws that New York passed in a hissy fit and basically dramatically shrunk them already. And I think they're going to get shrunk even further. I think the judge did a pretty good job on what he assessed. I think he let some laws stand that will not stand down the road because I think he applied the wrong historical precedent. I think when that's brought to his attention down the road, I think that will get cleaned up. But the bottom line, there's no doubt this is a dramatic victory for the Second Amendment because it took New York and it slapped them down dramatically and reduced the scope of a lot of these ridiculously dumb new gun control laws passed in hissy fit in the wake of NYSERPA versus Bruin. Okay, breaking news. I know it's talked fast. I know I got a lot of information out here fast, but it was critically important to get this to you as soon as possible. That's why we did it, and we'll break it down into greater detail. But the bottom line is be very, very happy about this. I think there's a lot more happiness coming, but this is a great start, and there's more to come. Okay, hope you learned something. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.